Thank you everyone for joining us for part 7 of our countdown to the UPC webinar series. My name is Matthew Royle from Taylor Wessing in London, and I am joined in Munich by my colleague Sara Burghart. In November last year we spoke in part 6 about the jurisdictional options for a claimant and their consequences when lodging an infringement claim. Today we follow up on that webinar by discussing the rules that govern where a revocation and or declaration of non-infringement action must be lodged. We also consider how these are affected by infringement actions and the possible consequences for bifurcation or transfer of actions between UPC divisions. We will also go on to say a little about how jurisdiction can be challenged by way of preliminary objection. But before moving on to these issues, there are some developments to report on since our last webinar. Firstly, Finland ratified the UPC agreement on January the 19th this year. It is the 9th country to do so, and this means that only 4 further ratifications are now required before the agreement can come into force. Although these ratifications have to include Germany and the UK, which are still outstanding, full ratification does appear to be getting quite close. Secondly, on the 28th of October last year, the European Commission published a communication entitled Upgrading the Single Market, More Opportunities for People and Business. This document states that the Commission is considering the idea of creating a unitary SPC, which would be based on the unitary patent, either as an alternative to or in addition to national SPCs. Now, although this idea is not expected to come to fruition anytime soon, it is not thought that it's going to prevent the unitary patent regime from coming into place upon ratification of the UPC agreement. Thirdly, the EPO has announced it is legally, technically and operationally ready to deliver the unitary patent. This means that renewal fees and their distribution between national intellectual property offices and the EPO and other budgetary and financial rules have all been finalised. And finally, on the new developments, that is, on 25th of February this year, the Preparatory Committee of the UPC published the agreed rules on court fees and recoverable costs of the UPC. Under these rules, there will be 2 kinds of fees in the UPC. Firstly, fixed fees, which are payable for initiating an action, such as infringement, declaration of non-infringement or revocation. Also fixed fees for applications of search and seizure evidence, leave to appeal and other procedural steps. In addition, and secondly, for infringement actions and declarations of non-infringement, there will also be a value-based fee. Full details are available on our UPC web pages. So turning to the main subject of this webinar, as with infringement, the jurisdictional rules dealing with revocation and declarations of non-infringement, which I can refer to sort of from here on as DNIs, are found in Article 33 of the UPC agreement, specifically subparagraphs 3 to 5 of that article. Although there are rules of procedure that provide more detail and which we will refer to and come across later as we go through the presentation. As we did with infringement in webinar part 6, we've broken down the application of these jurisdictional rules down into some simple scenarios, beginning in this case with the basic scenarios 1 and 2. These scenarios apply to both revocation and DNI actions, which is why it is convenient to describe them together here. However, there are some further issues associated with DNIs, which Sara will speak about a little later. In this webinar, we will also address the slightly more complex considerations that arise when a subsequent infringement action is lodged, which concerns the same parties and the same patent as the revocation action. This includes how a bifurcated action can come about and how actions can be transferred to divisions of the UPC in which they were not originally lodged. But before I go on, remember that even if it is unlikely to happen in most cases, it is open to the parties, in principle, to agree with each other on the forum in which they would like the action to proceed. So moving on to revocations and DNIs. The first scenario, which is shown on this slide, presumes an infringement claim on the merits concerning the same parties and the same patent has not already been lodged. In this situation, a clearing away strategy, the revocation claim must always be lodged in the central division. A classic action to clear away of a patent is therefore relatively straightforward. An action to lodge a DNI follows exactly the same rule and may even be lodged together with the revocation action. Unless an infringement action, which concerns the same parties and the same patent, is subsequently lodged, the revocation action cannot be moved from the central division, and nor can the DNI. However, if an infringement action on the merits has already been lodged in a local or regional division, according to the rules we explained in webinar part 6, a different rule applies. In these circumstances, a revocation action and or a DNI between the same parties and relating to the same patent as the earlier infringement action must be lodged in the same local or regional division as that action. In other words, because the claimant in the infringement action was first to lodge, it detects a forum in which the revocation action must be heard. As we also explained in webinar part 6, the claimant may have had a choice of division in which to lodge and chosen a division which it thinks will favour patentees. The party bringing the infringement action has therefore seized the initiative. It is a point in favour of a third party avoiding any activity that can be deemed an infringement instead of clearing away. Now, the central division as the forum in which the revocation or DNI can be lodged is not affected by an earlier claim for an action other than infringement on the merits. In other words, a preliminary injunction, other provisional measures, or any other action listed within the exclusive competence of the UPC, which has already been lodged or in a local or regional division, does not affect the rule that revocation action must be lodged in the central division. However, when preliminary injunction is on foot concerning the same patents and the same parties as a revocation action, that is in the central division, the revocation action must be accelerated. The purpose of this is to ensure that the validity of the patent being enforced can be tested as soon as possible. For those revocation actions that are lodged centrally, there is then the question of which branch of the central division the action will be heard: London, Paris, or Munich. This is determined by a mechanism by which the action is allocated by the registry according to the subject matter of the invention claimed in the patent. This can become more complex in situations where there is more than one patent in the action, and the patents or even their claims cover different subject matters. What about if an infringement action is lodged after the revocation action is started, but is between the same parties and concerns the same patent as that action? The answer is that there is a choice of division in which to lodge an infringement action in these circumstances. That is, the infringement action can be lodged in the same court as the revocation action, as shown on the left-hand side, or it can be lodged according to the general rules that apply to lodging of infringement actions that we discussed earlier in our earlier webinar. This might be the local or regional division in which the infringement occurs, or the domicile of the defendant. And this scenario is shown on the right-hand side of the slide. As a result, the patentee or exclusive licensee bringing the infringement action appears to have a chance to seize back the initiative on forum. But it is not that simple here. Note that on the right-hand side of the slide, where the infringement action is lodged in a local or regional division, there is now a split forum between actions concerning the same parties and the same patent. In other words, the action is bifurcated. As you'll see in the next slide, this scenario triggers a decision-making procedure by the local or regional division on what to do with these actions. This procedure takes place under Article 33, subparagraph 3 of the UPC agreement, and let's turn to that now. So I've now moved to the bifurcated action on the previous slide, up to the top right-hand side of this slide, and called it B in red. But before going on to look at what can happen as a result of the Article 33, subparagraph 3 decision, which is what is shown by the arrows and boxes at the bottom of the slide, I first need to explain that there is another scenario that triggers an Article 33, subparagraph 3 decision. This is the one shown by the red letter A. The scenario A results because a revocation counterclaim may be lodged in response to the infringement action in B, even when there is already a revocation claim lodged in the central division concerning the same patents and the same parties. This counterclaim must be filed in the same local or regional division to that seized with the infringement action. If there is a revocation action already lodged, this means that there are potentially duplicative revocation actions. If so, the registry must, as soon as practicable, notify the President of the Court of first instance of the central revocation action, the infringement action, and the counterclaim for revocation. When the revocation claim already filed in the central division concerns the same parties and the same patents as the counterclaim, the panel assigned to hear the central revocation action must stay it. This stay is represented by the white circle with the line through it in the green box. In any case, whether it's a revocation counterclaim to an infringement action lodged in the local or regional division, that local or regional division must go on to make a decision under Article 33, subparagraph 3. So what is decided by the local or regional court under Article 33, subparagraph 3? There are up to three alternatives represented by the three alternative routes the arrows take at the bottom of the page. The three alternatives are, under Article 33, subparagraph 3, subparagraph A, the local or regional division proceeds with both the action for infringement and with counterclaim for revocation, and requests the President of the Court of First Instance to allocate from the pool of judges a technically qualified judge with qualifications and experience in the field of technology concerned. This is represented by the blue box at the bottom left-hand side of the slide. Or, under Article 33, subparagraph 3, subparagraph B, the local or regional division refers the counterclaim for revocation for a decision to the central division and suspend or proceed with the action for infringement. This is the result depicted by the blue and green boxes at the bottom middle of the slide. Or finally, under Article 33, subparagraph 3, subparagraph C, with the agreement of the parties, the whole case is heard by the central division. This is shown in the green box on the right-hand side. As the slide shows, of the three alternatives open to the court, only one results in the permanent bifurcation of the action, and that's the one shown by the two boxes in the middle at the bottom of the slide. However, the scenario on the previous page leaves a number of open questions. For example, the rules are ambiguous as to whether it is possible for a revocation action lodged in the central division in the B scenario shown, that is where there is no counterclaim to the infringement action in the local or regional division, can ever be transferred away from the central division. This doubt is represented in the slide with the red dotted line and the question mark. There is also some doubt as to whether an infringement action lodged in a local or regional division that is met with a revocation claim concerning the patent rather than the counterclaim can ever be moved from that division under Article 3, subparagraph 3. Similarly, if an infringement claim and a revocation claim concerning the same patents are lodged in the central division, there appears to be no way either action can later be moved. These issues will have to be clarified in due course by the judges of the court, and although they appear technical, they may prove to have tactical value in terms of where and the manner in which cases are lodged. So let's look at what happens if after the Article 33, subparagraph 3 decision is made, the infringement and revocation actions remain bifurcated. This has been an issue of considerable attention because we're concerned that a so-called injunction gap will arise. An injunction gap is where the claimant in the infringement action is able to obtain a final injunction before the validity of the patents being enforced can be tested in the revocation proceeding. In other words, a faster infringement procedure can favour rights holders. So how do the rules of procedure address this? The answer is that in Article 33, subparagraph 3 decision, if the decision is made in favour of bifurcation, there are three further possibilities. Firstly, if there is a high likelihood that the relevant claims of the patent being enforced are invalid, then the panel must stay the infringement action until a decision has been made in the revocation action. This is under Rule 37.4 and 118.2b of the Rules of Procedure. Or secondly, the panel, at its own discretion, can decide to stay the infringement action anyway, pending a final decision in the revocation proceeding. Again, this is under the same rules. Or thirdly, if the local or regional division proceeds with the infringement action in parallel to the revocation action in the central division, the judge rapporteur of the central division must endeavour to accelerate the revocation proceedings. This is under Rule 40b and Rule 37.5. And we must endeavour to fix the oral hearing of the revocation action before the infringement action is decided. So if there is a stay of the infringement action as a result of options 1 or 2 just outlined above, bifurcation may have the consequence for a patentee, particularly if the patent at issue is perceived to be weak or invalid, that the patent in dispute is held invalid at first instance before a decision on infringement. This potential disadvantage to the patentee operates as a balancing factor with the injunction gap risk to the alleged infringer. Similarly, the acceleration of proceedings and the direction to the judge rapporteur to fix, where possible, the revocation hearing before the infringement period is also intended to prevent the injunction gap. I'm now going to hand over to Sara Burghart to talk about the reasons why a case may or may not be bifurcated and to speak further about the declarations of non-infringement.
Thank you, Matthew. When a panel has made a decision under Article 33, subparagraph 3, it is required to give brief reasons for that decision in its order. The factual context within which Article 33, subparagraph 3 decisions are made by panels of the UPC can, of course, be expected to differ widely. Decisions under Article 33, subparagraph 3 are also discretionary. However, over time, general guidance may be expected to emerge on how the UPC divisions should apply the alternatives available to a panel, including those factors that are most important. At this stage, one can only speculate, but we would expect the following considerations to be relevant. First, consistency. Hearing infringement and validity cases together has the benefit of ensuring that the patent claims at issue are construed consistently for both actions, revocation and infringement. This is because when these actions are heard together, it is inconsistent, for example, for a claimant to seek a broader construction of the patent because it helps them in terms of their infringement arguments, but at the same time seek a narrow construction because it assists them in defending the sufficiency of the patent. In other words, hearing the action together means that adopting one position on infringement may squeeze a party on the position they take on validity or vice versa. Secondly, case management. Consideration must be given to general principles of case management, in particular considering whether taking a particular step justifies the cost of taking it and giving directions to ensure that the hearing of the case proceeds quickly and efficiently. Specifically, in those cases that we described earlier, in which a revocation counterclaim in a local or regional division follows the lodging of an earlier revocation action in the central division, the panel is required to take into consideration how far the central revocation action had advanced before it was stayed. If the central revocation case has advanced significantly, maintaining the stay of the central revocation action may be difficult to justify. It might be better that the revocation is allowed to proceed in the central division without the infringement action, so that it is not delayed while the infringement action gets up to speed. In the judges' discussion about the UPC at last year's Fordham IP conference, which Taylor Wessing chaired, judges and former judges gave their own impressions of the factors that might influence whether a revocation action and an infringement action are heard together or not. In particular, Johannes Karche, the head of the Patent Division of the Federal Ministry of Justice in Berlin and formerly a judge at the Federal Patent Court in Germany, said this in respect of so-called patent trolls. If you are in that situation where a patent troll comes along, it has a shaky patent which can be seen already at first sight, what would you do if you were UPC judges? I think it would be clear that in this case it would be kept together. What Mr. Karche means is that the case would be kept together to avoid any risk that an injunction can be obtained on a weak patent. Although in this situation, a stay of infringement proceedings might also be used. He then says, the other extreme is that the defendant invokes invalidity as a random measure. You can see that it is only to burn time. Here is the possibility for the UPC to bifurcate in that case and get on quickly with the infringement decision. So, on the other hand, there are situations in which validity is raised only to delay. It will be up to the judges to use their skill in determining which situation these are. At the same conference, Professor Sir Robin Jacob, formerly a Lord Justice of the English Court of Appeal, addresses concerns about weaker patents exploiting the injunction gap. He stated, the patentee can hardly come along and say, I'm worried about the validity of my patent, so please bifurcate because I want to win. What is he going to say? If he says, I want to bifurcate because I will get the infringement decision quicker, then the judge will probably say to him, why didn't you ask for an interim injunction? Does the judge think that bifurcation will happen very often? He says this, the only places I do worry that it might happen is in some of the weaker parts of this court. And we have to recognize that there may be local divisions that are not as strong as some other local divisions, who might say, oh, it's a little bit difficult for us, but strong judges will not bifurcate. Let's turn our attention to DNIs in a little more detail, in particular to their relationship with infringement actions. This is an issue because an infringement action may be lodged in a local or regional division after a DNI has been lodged in the central division. This has consequences if two conditions are fulfilled. One, the infringement action relates to the same patent, and two, the actions are between the same parties or between the holder of an exclusive license and the party requesting a DNI relating to the same patent. The consequences depend on whether or not the infringement claim is filed within 3 months of the DNI. When the infringement action is lodged in a local or regional division, the registry proceeds to examine the formalities of the statement of claim on the action and records the action in the register. The registry then notifies the president of the court of first instance and the presiding judges of the other panel of the co-pending actions as soon as possible, together with the relevant dates of the actions. If the date of receipt of the statement of claim for the infringement action is within 3 months of the date of lodging the DNI in the central division, the president of the court of first instance will require the DNI to be stayed. However, On examination, if it appears that the infringement action was not filed within 3 months of the earlier DNI, the action is not stayed. Instead, the presiding judges of the central division in which the DNI is lodged and the local or regional division in which the infringement action is lodged must consult to agree on the future progress of proceedings. The future progress of proceedings may be the stay of one of the actions, but the rules of procedure do not provide guidance on the circumstances in which this might happen. One factor determining the progress of the action is likely to be the period of time between the lodging of the actions. If the central division action is advanced, it may be appropriate to stay the infringement action. But it still remains to be seen how the judges will deal with these circumstances. There is also an open question about what happens when an action for revocation is lodged in the central division together with a DNI, if it relates to the same patent and is between the same parties. In these circumstances, if an infringement action is lodged within 3 months of the lodging of the DNI would seem to be stayed, as we have just seen. But what happens to the revocation action? Does the Article 33, subparagraph 3 procedure that we discussed earlier apply? It would seem so. But if the infringement action is lodged after 3 months from the lodging of the DNI action, the applicable rules are less clear. The Article 33, subparagraph 3 provisions may apply between the infringement and revocation actions. But what about the DNI? There is the obligation of the presiding judges of the central division and local or regional division to consult to agree on the future progress of the proceedings, and this may be how the progress of such a combination of actions can be resolved. The result could be the transfer of all the actions to the central division, or the stay of either the infringement action or the DNI, or to the extent that principles of good case management permit, allowing all the actions to continue. Finally, let's turn our attention to the formalities of the statement of claim. When a party has determined the appropriate division in which to lodge its case according to rules we have explained in this webinar, in our earlier webinar, part 6, this must be indicated in the statement of claim. There must also be an explanation in the claim of why that division has competence. Alternatively, if the division has been agreed by the parties, the statement of claim must be accompanied by evidence of this agreement. The statement of claim must also contain information about any prior or pending proceedings in a UPC division that relates to the same patent. This includes any action for revocation or a DNI that is pending before the central division, together with the date of that action, and any other action in a forum such as the EPO or a national court. The registry will then check these details. Providing the formal requirements have been complied with, the action will be assigned to a panel or, where requested by the parties, to a single judge. In cases filed in the central division, actions are distributed by the registry according to the subject matter of the patent in dispute, as Matthew mentioned earlier. It is then within 1 month of the service of the statement of claim that the defendant may object to the competence of the division chosen by the claimant in respect of any division or any cause of action. Such objections are made by what is called a preliminary objection. As soon as practicable, after the filing of the preliminary objection, the registry must invite the claimant to comment. The claimant then has the opportunity to correct any deficiency within 14 days of service of notification of the preliminary objection, or the claimant may submit written comments also within 14 days. The judge rapporteur is then informed of either activity. Then, if the claimant has corrected the deficiency and indicated an alternative division that is competent, the judge rapporteur will refer the action to this division. Otherwise, after expiry of the 14-day period, the judge rapporteur will decide the preliminary objection, having given the parties the opportunity to be heard. A decision by the judge rapporteur to allow the preliminary objection may be appealed with leave of the court of first instance within 15 days of service of the court's decision to that effect. If the court of first instance refuses to grant leave within this period, a request for a discretionary review may be made to the Court of Appeal within a further 15 days. If there is no preliminary objection to forum, the defendant is presumed to submit to the competence of the division in which the claim is lodged. And so I will finish by handing back to Matthew in London.
Thank you, Sarah. So that concludes our webinar for today. In our next UPC webinar, which is on the 11th of April, we will be providing an update of part 1 in the series, the subject of opt-out and the transitional period. Then in May, part 8 of the series, we will look at proceedings on the merits in the UPC in overview. We do hope you'll be able to join us for both of these. In the meantime, our final slide shows details of the Unified Patents Court website that you can look up in the intervening period if you have any questions or just want to see what's going on between now and our next UPC webinar. Thank you all very much for listening.